Welcome to the Sober Christian Gentleman podcast. This is Henry. I decided to do a podcast on the court system because there's not much information out there. So I thought I'd share some insights and perspective and some kind of inside baseball on the court system, how it works, right? Some a bird's eye view and some different information about it in the way that I do. And I thought you might think that's interesting because very few people are talking about this, and it's part of our lives. Almost every day there's 10 news stories about this court did that, and this court did that, and the other thing, and so-and-so is being dragged into court, and criminal charges this, and criminal charges that. Most people have no idea how the system actually works, so I'm going to try to give a overview of how it works so you can gain a better understanding. So when you're hearing these words, you'll know a little bit more what it means. All right, on with the podcast. We will begin with an opening prayer. God, give us the patience to accept the things I cannot change, the courage to change the things that I can, and the wisdom to know the difference. God, give us discernment so we can see with clarity, followed by conviction, to act appropriately at all times and in all things. We ask that you bless us with the armor of God, cloak us with your divine protection, so that we may boldly walk in the world, to courageously be the peacemakers and make the world a better place for all your children. We ask that you move our hearts so that we know when to use the sword of the Spirit or the sword of steel to do right for ourselves, our families, and our communities. We ask that you move us in constitution to be humans who stand tall with courage, speak truth, and lead by example. We pledge on our sacred honor to rebuke evil, to speak out against evil, and to act to stop evil. We ask that you move our hearts so that we may know with absolute certainty the best way for us as individuals to act in our own way. In the power and in the name of Jesus Christ, we banish all negative entities, all evil spirits, all demons from our presence immediately. In the name of Jesus Christ, we command you, we compel you with the power of the Most High God to leave our presence for now and forever. Do not return, go now. In the name of Jesus Christ, we express with our full intention, with our freedom of choice, this area is now declared with the authority of Jesus Christ unequivocally, absolutely, totally clear of all evil entities, spirits, and energies. We say these things in Jesus' name. Amen. I thought I would do a podcast on the court system because people don't seem to kind of understand the history of courts, how we got here, what the courts were, what they are, that kind of thing. So we'll go back in history and say about 1,000 years ago. We'll start there because that's kind of the most recent period that can be traced the lineage from, right? So you had these courts that were called the king's courts, and essentially the court was wherever the king was. If he held court, you basically showed up to his place, wherever it was, whether it was a palace or a residence or whatever. And as soon as you're walking within the periphery or the perimeter, the area within which the king was, you're in his court. And people know the term court jesters. So court jesters were the people who were supposed to make the king laugh and make him happy and be jovial and all that stuff. Court jesters were there. Then there was the court guards and the court entourage of all the different advisors to the king. And they'd be advising him about what to do on this and that. People would bring their issues to him. And if he saw fit to see them, they'd come to his court. He'd hear them out and then make a decision. And whatever he said was final. If he said, he didn't like your face, he want your head gone, your head would be chopped off. If he liked your story and didn't like what he heard about some other guy, even though he had no evidence to the contrary, he could just order the other guy killed, that guy's land's given to you. And there's many different examples of just people who had favor with the king because they knew him for some reason, or they were just able to charm the king into getting what they want. They're able to get what they wanted, and whatever the king said went. And he had these enforcers called the sheriffs or the royal guard or his military that would go execute his will, which means they might execute a lot of people, kill them, or they might just throw people off land and hand it off to someone else. And this is how the system worked. The king owned everything. The king of a kingdom, in theory, owned everything on that land and under the land and over the land. He owned all the birds, all the trees, all the animals, all the people, all the fruit and vegetables, all the worms underneath the ground were his. And this is the claim he had as being the king. Now, the real power to the kingdom was that the kings of recent times wore crowns. And if you followed my podcast at all, you know the symbol of the crown means the king has a higher power above him, which is the crown that sits on his head. The crown is the highest power in his kingdom, not the king. But most people had no idea because it was a secret pact by which the crown would grant him ultimate control over the lands of the kingdom as long as he did what the crown wanted. The crown was the hidden government. This is the network of controllers from the shadows. These are the agents for what I call the shadow people in many of my podcasts. So there's Team Evil and there's the shadow people. The shadow people are from in the shadows. You never know who they are. They hold on to massive wealth, technology, and all kinds of means of control. And they have this giant network that goes out in front of them. It's like a shell game of layers and layers and layers of agents in front of them until you finally get to the front-facing version, which is what you see in front of you. So a king was the front-facing version of the power structure. He was the known top dog in that area. And as long as he did what the crown told him to do, he would maintain power. And everything else he did, they didn't care about too much. As long as he didn't upset their plans for whatever. Now, that's the actual power structure of how this worked. People forget what the crown is, and they thought, oh, the crown was just a symbol of his power on his head, so everyone knew who the king was if they walked into a room. But I think it's kind of ridiculous because if you walked into a room, you'd pretty much know who the king was. Anyway, when you get down to it, the king, to the level of kingdoms, the king claimed ownership of everything in the kingdom. And then he would dispense or delegate authorities to people underneath him by granting titles and lands and privilege and all different things. This is how they created the titles of Duke and Duchess and Lord this and Lord that. These are all titles granted by the king to give to the people who were in his favor. And they would basically have to do something in return. They'd have to basically be loyal to him to, number one, get the title. And then once they got the title, they had to give him something in return. So if someone wanted to be a duke of a particular large chunk of land, it'd be, say, 10,000 acres or 1 million acres or whatever the size was. In return, the duke would have to raise an army, which meant that he had to actually figure out a way to recruit, say, 10,000 soldiers, train them, arm them, get them on horseback, get them ready to fight. So the exchange for these, million acres or whatever the size of the land was, and the title of Duke, was he had to actually raise an army. And he had to figure out how to do this. So he had to go through and recruit all the guys who could probably fight, offer them gold or life of luxury or whatever he had to do to get these guys together. So he had to get a standing army within a certain period of time or he would lose his title. So this is how the king actually created armies out of nowhere by granting titles and privilege to his friends. Now, as you go along, it gets very interesting because what ends up happening is these different titles of nobility started going along. People would be granted a title, then they'd lose a title, and they'd be granted a title, lose a title, and they were getting tired of actually granting, getting and losing titles. It became kind of ridiculous, so they wanted to have something that was more just, rather than the whims of the king. This is where they had there's something called the Grand Council, or at Runningmead. I'm trying to remember the name of it. It was basically known as the Great Document, which is basically the first declaration of kind of a modern government thing that people look back to. What it was the royalty, the the lords and ladies of just the lords. So it was basically the nobility of the time that got together and told the king, listen, king, knock it off. We want some consistency here to this legal system, and we don't want you just having your whims. And if you resist us, we'll just overthrow you as king and put someone else in as king who will actually go by these rules. So they had the agreement, and the king abided by the rules for a little while, and then he tried to take him back, and it was a big fight for a while. The point was, this is the first instance whereby the nobility demanded having actual equal justice rather than waiting for the whims of the king to either strip them of titles or gain them titles, and on it goes. What ended up happening was the king created these courts that had different names. There was the Court of Chancery and the Court of Lords, and there's all these different names for different times as it iterated through time. And to keep it simple, we'll talk about two courts that were basically the most common in this system. And the courts were common law courts or courts of equity. The reason why the distinction is, this is where it's really important, is that the courts of common law were dealing with rules and regulations and case law. So what happened was, there's all these different judges who through time started writing down these judgments in these books, and like Blackstone's book on judgments or whatever, and he basically collect all these cases together and create these tomes of authority, where basically the idea was, if the judge ruled a certain way to a certain group of parties, they should continue ruling that way in the future to keep everything consistent. So in the beginning, when they first popped up these courts, and it was basically the nobility that were the judges and the lawyers and everything, it was basically, they played jazz. They just did whatever they felt like. They just did whatever they wanted, kind of like the king did, except it was a bit more cordial, I guess. You weren't worried about getting your head chopped off by a whim. So that was making forward progress for the nobility. But anyways, as it went along, they started getting more and more rules of conduct and rules of this and rules of that. And people had to do things a certain way and file paperwork a certain way. And it wasn't just show up and say your piece and see what happens. After a while, it became very formalized as time went on. And then as things became more formalized, it became more nuanced in its rules. And the rules became within rules, and then then the judgments had to go a certain way because of what they up with, is the idea of a precedent. Precedent means you have to look backward to be looking forward, to make sure things are consistent. And it goes forward in time. It's just like a giant mess where there's rules going forward, rules going backwards. And this is where there's the two main courts that were going on. One that was under the jurisdiction of common law, which is basically under the rules and regulations of the land and the customs and of the time. And then there was the other thing called courts of equity. Courts of equity was where anything could happen, because it was based on the discretion of the king, of his ability to just do whatever he wanted. So it was basically the idea is to find justice in the matter, no matter. It doesn't matter what the rules are. They don't care for what came before. They only care about who's in front of them, what is the best thing to do between the parties, and to make a judgment in that way. These are the courts of equity. They're basically just doing whatever they think is just in the case. And just to you and just to me and just to them doesn't always mean the same thing. But anyways, they were able to just do whatever they wanted. People would come to them. There's even a sub-court called Court of Chancery, which is basically like take your chances in that court, right? It was like tongue-in-cheek kind of thing. And anyways, it's just this giant history of craziness. Finally, you get more into the more modern times, right? Within 500 years, and things started getting more standardized. Okay, I'll go back to 1300 years. So 1300 AD, this is when things really became formalized in England, because this is where the Crusades were going on. And you had all these guys going down, protecting these parishioners that were making their journey down to Jerusalem to visit where Jesus died. And it was a big money-making kind of endeavor that profited the Knights Templar, who were guarding people from the people trying to rob them on the trails. They had to create the first form of banking system whereby people would deposit, say, 1,000 pieces of gold with the Knights Templar at the beginning of their journey. When they got to the other end, they could withdraw 1,000 pieces of gold, and in between, all they had was a piece of paper that was a letter of credit to them specifically. So no one else could actually cash in on that letter of credit, except the first form of banking that's modern version that was going on. It was the Knights Templar that did it. So anyway, we're going along, and okay, so there was this there's a chapel built called the Chapel to the Holy Sepulchre, I think it was, in England, that was basically a reproduction of the Temple of Jerusalem. And it gets into this really convoluted history that's really fascinating to read. And this is where the city of London was established as the center of power for the British Empire. And the city of London is not part of London. It's actually its own entity. It's its own jurisdiction. They have their own police force, their own mayor. It's a completely different jurisdiction. What happens in the city of London stays in the city of London. And this is where all the big banking cartels go, because there's no extradition treaty from there. They can do anything illegal they want. They can order hits if they want, and nothing will happen to them as long as they stay within the city of London. As long as they pay favor to the city of London, they're granted asylum there to do whatever they want to do. So here they are doing their thing, and we move forward in time. Now, in the same kind of couple blocks in the city of London, there was this bar that I forget the original name of it, but it's basically this tavern where people would go to start studying law, because law was a new thing being formalized in a kind of a new version. It was kind of like a renaissance of the legal system, legal theory, and jurisprudence. And people would go there as noblemen to study law, to become lawyers. There wasn't any really formal curricula. They just go there for hang out for a couple of years, come out being called a lawyer. And this is a tavern, so there's a lot of drinking going on, and that's one of the reasons for they call it you have to pass the bar, because you had to go in there, get blind drunk, and become one of the boys. But then later on, they came up with the name bar, which is the British Accredited Registry, to kind of hide that history. And it gets into this fascinating kind of convoluted thing, where now anyone who signs up as passes the bar, they're essentially a foreign agent working for the city of London. And most of them have no idea. This is the beautiful thing about the treachery that is the legal system, is that they have lies within lies within lies. And most people have no idea they're promoting the system that is completely corrupt as a system. It's completely meant to control us. It's not meant to be justice. It's not meant to be anything we think it's supposed to be. It's something else. Until you understand what it actually is, it doesn't make much sense to you. So as you're going along and you're studying the history of the legal system and lawyers and how they get their thing, it becomes very interesting in that the informal nature of it at the beginning is very interesting, because that leads us to how the thing developed the way it did. It was very informal. It was just lords that went and became lawyers. The lawyers were then presenting cases to judges who were also lawyers or local lords. You didn't need any accreditation other than you're a guy with a handshake and a deal. They went to the right places and they knew the right people. And things moved on from there. And this historical context is more important to understand where we started off, where we kicked off with. Because as the British Empire spread around the world, they started spreading this idea of common law and the legal system, and they started setting up these courts in India and in the colonies in the United States and Canada, Australia, New Zealand. All these colonies started getting this legal system called the common law legal system. And as things went forward, it started getting more and more formalized. And there's a point where it transitioned where only noblemen could be lawyers, to anyone could become a lawyer if you actually went to these universities to get a university degree. You had to get your degree and then pass the bar. So whatever type of education you got, you had to get the background in law, and then you had to pass the bar. You're only allowed to actually practice law in the British Commonwealth if you have your bar license. This is the part that's so interesting, is that the only way you can actually practice, they even say practice. Are you doing law? No, you're practicing law. It's like just this concept, this segment I'll kind of wrap up here, but think about it. If you're practicing for a race, are you racing? No, you're practicing for the race. See, you practice for the race until you get to race day, then you're no longer practicing because you're actually racing. See how that works in common English? This is the thing that is so interesting, is like it's hidden in plain sight. They let you know they're practicing law, but they're not actually doing law. They're not actually doing what's lawful. They're actually just practicing for the day they might actually do it. This is the legal words they play, the legal games where they pretend one thing and do another. They do it right in your face. And until you know the difference, you don't know the difference. I'll wrap it up right there in this segment. All right, so I'm going to try to frame what the courts look like as a schematic so you can better understand what's going on here. I've given you some history of how the courts were kind of created. Now I'm going to give you the framework of how they're organized. And most people just don't understand the terminology. So I'll try to keep it simple because they've just rewritten a bunch of words to mean whatever they want to mean. It's like taking a common English name and then giving it a meaning that wasn't there before. It's got a new definition. So this is where there's a term called legalese, as in legal ease. Legalese is its own language that unless you know the words, you don't know what the meanings are. And someone can be having a conversation right in front of you, and it might sound like one thing's going on when something completely opposite is going on. So anyway, I'm going to get into the framework of how the courts are structured. So the general kind of way that they're structured in the West, we'll keep it simple to the West, is that you have multiple layers of court. And okay, let's come at it this way. In the West, we have these different things called democracies. Democracies is just a code word for there's a powerful group of people who are ruling things, but it's not you. But you get a chance to vote once in a while and see if it has any effect. That's what democracy means today. Now, what ends up happening is you have these things called governments that are nation states. And these nation states are very curious because up till a few hundred years ago, they didn't really exist. All there was kingdoms. So I'll come at it from this angle. Not too long ago, there was kingdoms everywhere. And the kingdoms were connected by a hidden network called the Crown Network. The Crown Network was the ones who actually held power, and they would bestow it to a king who was willing to work for them, and he put a crown on his head. That was a symbol that he was part of their network, part of a larger gang. And you couldn't mess with him because he'd be messing with the whole crown gang. That was kind of the trade-off, right? If a king had no crown, it meant he was independent, and you're only dealing with him and his little entourage, not with this larger network. So there's people who saw that it would be an advantage to be part of the larger gang network rather than being independent gangs doing things on their own. So this is how the kingdom network began. And then a couple hundred years ago, they started folding this into nation states. And what they found was they did a test with the British Empire. And the British Empire was basically this giant empire run by the King of England, or the Crown of England. And it worked out pretty good, but they realized to actually have global worldwide conquest, they needed a different format. So they needed to submerge the British network. The British Empire went underground. And it seemed like almost overnight, all these different colonies became nations. So like New Zealand became a nation where before it was just a holding of the crown. Australia became a nation where before it was a holding of the crown. And all these different colonies became nations. Like magic, overnight, usually bloodless transitions. So no one fighting over it, which is kind of weird. And it's important to understand a little bit of history here. So I'll just give the American colonies and Canadian colonies as an example. So what happened when the American Revolution happened in 1776 was that people were tired of having this experience of having everything taken from them by the king. They were working their butts off to terraform this land that was basically wilderness and turn it into functionable, profitable land, into farming and things like that. And I've done a whole different series on the American history where there really was stuff here, but the point is that this is the theory, is that colonists would leave Europe and go to these colonies in America so that they could make a life for themselves. They're able to be entrepreneurs, able to actually build wealth on their own, able to get away from the tyranny of the legacy of the kingdom format. So what happened was in the colonies, there were so little rules that people were actually able to make profit, make entrepreneurial ventures, and make themselves into, profitable enterprises. They'd be able to earn a lot of income for their families using their intellect and their creativity and their hard work. This did not exist in Europe because Europe was under the tyranny of both the Catholic Church and the British Empire. The problem with the British Empire is you had the king, but then you had his entire entourage and whole royal families and all these different royal lineages that demanded their pound of flesh, even though they did nothing for it. And this is the thing that was driving people out of Europe, because it was complete tyranny. It was complete insanity. You get your butt off to actually create something new, and some noble person comes in and just steals it from you because he has the right to do so. Even though he's not creative, he's not entrepreneurial, never had the idea, never sweat for it, never created it, he can just steal it from you. And the courts would find it in his favor because he's royalty and you're not. People were tired of this, so they wanted to get away from it. And the opportunity was to go to the New World. So they went to the New World, which is the American colonies. Now, the American colonies found an opportunity, or provided an opportunity for people to actually go from the ports out into the wilderness and start terraforming the land. They took vast swaths of forest, cut down trees, turned into lumber, sold the lumber or built stuff with it, and then created farming communities where they created an abundance of fruit and vegetables and other things. This is how it went. So all these people were finding they were able to create a life for themselves as long as they got away from the government, right? Go 20 miles into the woods, the government's not there. Why? Because most of the government agents were nobility who didn't like getting their boots dirty. They liked hanging out in the taverns, and they liked going from, grand house to grand house, these costume parties and stuff. So as soon as people got into the wilderness, they started to become more free. They become very independent. They started making wealth for themselves. And then the cities started to grow, encroaching on the people who made their way in the wilderness. So the people who made their way in the wilderness had to keep going deeper and deeper and deeper into the wilderness to become free again. There was a point where there was nowhere left to go in the eastern side of what is known today as the United States. You could go all the way to the west, but the west wasn't really explored yet. There was a point where people were just tired of it. They were tired of the king stealing their stuff. They were tired of the noblemen stealing stuff. They were tired of just being worked to death for no benefit to them. And they said, okay, enough's enough. So they decided to rebel. They actually organized themselves, a little rebellion going on. And what they did was they declared war on the King of England. They said, we're not putting up with your stuff anymore. We're doing our own thing. We're going to be our own nation. So they went along the path of making the Declaration of Independence. At the time, the printing press was in full swing in the Americas, and there's opportunity for people with great ideas to get those ideas out to the masses. So there's a guy named Thomas Paine who wrote this thing called Common Sense. Common Sense was a booklet that explained how you have to be insane to want to live under the tyranny of a king if you're not the king, which is everyone but the king. So this booklet called Common Sense went out. People read it and were like, yeah, enough of this nonsense. And they were ready for a fight for independence. Then the Declaration of Independence came out, which is a beautiful document. You should read it. And they basically declared themselves independent of the king. And they state their reasons why they were going to do that. So this kicked off a bloody revolution against the king. And of course the king sent not the king's men, but he hired mercenaries called the Hessians, which were these German mercenaries that came in, and they were very cruel and very evil. And they tried to quash the uprising militarily, but they were defeated by the colonies. Because what was not factored in here was that people actually believed that the colonies were their homes. They believed they were defending the homeland from an invasion by the king. People react very differently when you're attacking them on their home front. So the actual colonial army was victorious. They defeated the king's mercenaries and the king's armies, the king's navies. And there was a intervention that actually helped the colonies, which was the Tsar of Russia sent his navy to blockade the British from bringing their navy ships and just blowing all the towns out of existence with their cannons, because the British Navy could have just pulled into port and started firing their cannons until they ran out of shot, and then went back and refilled and came back and did it again. If they did that, they would have leveled the cities that were all the port towns. But because the Tsar of Russia came in and intervened and put his navy between the colonies and the British Navy were not able to do that, and they had to actually fight a ground war, which put them at a disadvantage because the British were a naval power, not a military power, like a ground power at the time. So anyways, the colonies won. Years later, they brought in this other thing, which was the Constitution of the United States, which is a flawed document. And there's a lot of controversy there, but for the point of this story, this was created. There's the Republic of the United States of America as a representative republic. So that's the government that was set up. And then they had the three parts of the government: the legislative, the executive, and the judiciary. Now, the legislative was supposed to be made up of people voted into power by the people of the United States. This is the theory, is that they represented the people of the United States. At the beginning, there wasn't a lot of them because the colony was not that big. Now, as you go, okay, so yeah, there's the legislative, which is supposed to make the laws and regulations and all that stuff, decide taxation. And then there's the executive, which is the president and his entourage. Now, the point of having a president, they saw, was for dealing with foreign matters. They knew they needed someone who was a guy who could give his word and keep it to foreign powers. So he could go somewhere, or a representative could go somewhere and say, President XYZ gives his word that he's going to do this, that, and the other thing for the term as he is in office. And they relatively knew that his word was good, right? It's a guy giving his word. It's not a group of guys arguing over something. So they needed one guy to actually be outward facing to make agreements with other nations and kingdoms and such. That's the point of having a president and the executive. It's changed a lot since then, but that was the point of it. Now it's metastasized in this giant bureaucracy with like 1 million people in it. But anyway, it started off with one guy and a couple secretaries. Then there was the judiciary, which is supposed to make sure that the legislative did not get beyond the bounds of the Constitution, and the executive did not get beyond the bounds of the Constitution, because the point of the Constitution was to limit government, not the people. People just fought a bloody war to be free of a tyrannical government, and they did not want to allow another tyrannical government to replace the one they just fought off. That was the point. Since then, there's been a lot of skullduggery, and I'm not going to get into that for this podcast because I've been exploring it in other podcasts. The point is, there's 3 branches of government: judiciary, executive, and the Congress. And this is the point, is that there was separation of power, so no one could become too powerful and become a tyrant and ruin the regular people's lives. That was the point. So anyways, you have this legislative branch that's supposed to make laws for the good governance of generally the thing called the United States. It was to make life easy for people. Very quickly, though, all the positions of government were filled by British agents because there was no law against not being a British agent and taking over power of the United States government. So very quickly, almost everyone in the government was a British agent doing things in the interest of England. So here you go. That's the kickoff for the United States kind of taking a hard left turn there back into tyranny, pretending to be a republic. So I'm not going to, okay, the relativeness of this particular example is that the people fought a bloody war to be free of the British Crown in United States colonies. Now, just north of them, there was another colony. This is called it was generally known as the Colony of Canada. The Colony of Canada was basically the same group of people. They all came from the same places. They're part of the British Empire. They came from England and all these different other places dealing with the British Empire, and they relocated to this place called Canada. And Canada was just north of the United States, and it was all the same thing. The difference was when the Crown realized the people of the colonies had what it took to actually fight them and get free of British rule, they did a little switcheroo and a little trick to try to make sure the North Colony did not do the same thing that the South Colony did and become free of British rule. They thought it was very inconvenient, very costly. They were going to maintain control anyway, so why not just do it in a cheaper way? So the cheaper way they figured to maintain control is to just, voila, ta-da, Canada became a country. How? It's not sure. It's like magic. They didn't have to fight a war. Nothing really happened, except now Canada's a country. Who's in charge? Crown. Is it a country? Supposedly, but yet they're not independent. And this is the whole trickaroo that happened, was that people in the place called Canada, the colonies of Canada, were told, no, there's no need to fight a war. No, you already have your own country. Don't worry about it. I mean, you don't need to fight the king, go through all that bloodshed. It's very expensive. Oh yeah, just not go through the hassle. You already have your own kingdom. It's called a nation called Canada. And don't worry, there's no king there. It's just the people, the power of the people. Yeah. And they went through all this like propaganda stuff to explain how, this new nation of Canada did not have to fight a war, but yet became a nation, even though the vote for the nation to become created, called the British North American Act, was voted for in England in the British Parliament, right? So the trickaroo happened there where the thing called Canada became a nation without being a nation. They never actually became independent, and the whole thing is a giant convoluted theater ever since. And most people that live in the area called Canada have no idea what's going on because the government schoolings make sure they never know what's going on. And today it's even worse, where all they care about coming out of government school is LGBTQ++, two-spirit, whatever, and climate change. That's all they learn about. They don't actually learn anything useful. It's insane. So anyways, that's what's going on. The reason why I want to explain that is because that's how things got to the modern day version of the nation state, where the nation state has this thing where they have the legislative branch, which is supposed to be elected by the people. They got the judiciary, which is all the judges and the whole court system. And then they have the executive branch, which is supposed to be the king or president or prime minister, whoever is going to be running things as the executive. That's the formula that we have today because that's the way the government made it to be, to create a certain type of scam so that people don't realize they're not free, but everything seems like they're somewhat free and they have a chance to vote, even though their vote's not connected to anything. Okay, so we get that basic history out of the way. So what we have now in the West is this giant kind of scheme for the courts. Now, in socialist countries, they have a different kind of court system where they have this thing called civil law. Civil law is very different in that civil law is all about applying the law written by whoever the legislative is. This is the same in communist countries, France, which is weird. They've got civil law there. It's not the same as British law. In civil law, you're basically guilty until you're proven innocent. They basically, whatever's not written as legal is considered illegal. It's a real mess. In the common law system, like in the West, so the Western system of law, unless something is specifically illegal, it's called legal. It's assumed to be legal unless it's specifically called illegal. This was set up in such a way so that the people, the powerful, could make sure that they were doing stuff right on the edge of the law that was not deemed illegal yet, so they could get away with all kinds of stuff before anyone got wise to it. That's the point of this control structure. It's not that they're interested in justice. It was that they were doing all kinds of nefarious things and they want to be able to do it without any repercussions. So whatever's not deemed specifically illegal is called legal in the Western jurisdictions. Now, how this breaks down is that you have basically Okay, how am I going to phrase this? It gets complicated very quick because you have all these different jurisdictions that are all competing to be relevant to a specific issue. And sometimes they'll break it down into multiple court jurisdictions. So in the West, you have family court, and the only thing family court can deal with is family issues. There's traffic court, and the only thing traffic court deals with is traffic tickets and traffic violations, right? Then you have criminal court that deals with only criminal code and the application of the criminal code of whatever country it is to the matters at hand. So criminal court is different because it's a separate jurisdiction. And generally, you have this thing called civil court, which differentiates between criminal court and everything else. But it gets very convoluted because these things are meant to be convoluted. So that's why I'm trying to keep this in simple language. So in the general court system, the laws of the land are basically from the legislature. So statutes and acts are created. Statutes and acts are basically the law of the land, and then they get applied to people through different regulatory bodies. There's also an element of this where the courts are applying this, but there's regulatory bodies that apply it first. So there could be some sort of so the FEC is an example. The Federal Exchange Commission is it's basically dealing with all kinds of matters. I'm not going to get into the nuance here, but the point is you have regulatory bodies that are stood up by the government to regulate things before they go to court. If there's a controversy at some point, you can sue the organization and go to court and have it settled by a judge or whatever. The point is that there's all these different elements here where it becomes just this giant mess. It's a mess where there's rules within rules within rules. So we'll stick with the court system because that's the point of this podcast. Now in the court system, the judges on different levels, and I'll explain the different levels here. So you have your first level, which is where the pleadings happen. So the idea is you're pleading on your knees for help by a judge because there's a matter of controversy that you can't resolve on your own. This is where the pleadings are put in. And whether it's criminal court or civil court, it's both the same. You put in pleadings. And those pleadings start the process. Usually you have a motion to start something, which gets things in motion. There's all these vague terms that have double, triple meanings. And the first level of court is the guys who actually deal with the first level of information, right? So number one is the facts. The facts of the case need to be established in front of the judge. The facts are, who are the parties? Who is involved here? Number two, what is the story that got you to this point, right? Number three is, what is the law that's being applied here, as in what legal matter, where does the court gain its jurisdiction to rule one way or the other based on the law of the land or the statutes and acts? And this is where it gives it over to the court to actually decide. And if you go to trial, both sides get to bring witnesses in, and the witnesses establish the facts because you have these eyewitnesses who testify. Now, what's curious is not too long ago, to testify meant you're putting your testes on the line. If you lied in court, you'd have your testes removed. It's as simple as that. Like, how do you put it a different way? So guys were very careful about telling the truth in court because they did not want to lose their testes. And they only had so many testes to lose, so they couldn't lie too many times before that game was over. And they were no longer honorable men. If someone lost their testes, they could never testify again because they have nothing to put on the line, and they were not trustworthy. This is where the term came from, to testify. So anyways, usually they have all these guys testifying one way and the other, trying to establish the facts of the case. And the facts of the case are basically what the judge has to look at. Who are the parties? Have they established themselves as bona fide? Secondly, is the matter in controversy something that's within his jurisdiction to decide, as in according to the applicable laws and regulations and all that stuff? And then thirdly, who does he believe? If he has all those on a checklist, who does he believe is telling the truth? And depending on who he believes is telling the truth, he makes a a decision based on what's in front of them. And what most people don't understand is a judge's job is not to find justice. The judge's job is to be a neutral arbiter who's fulfilling his role as a judge. And you can almost imagine that in front of him is scales. The scales is like a balancing scale. And if there's more weight on one side than the other, then that guy should win the case. The moving party is usually called the plaintiff, and the person responding to the lawsuit is called the defendant. Whether it's a criminal court or civil court, it's usually, if it's the plaintiff would be the state if it's criminal proceedings, and if it's a civil proceedings, it's just regular people being the plaintiff going after someone who's the defendant. Anyways, the judge comes to some judgment based on all the different things that are put in front of him. And what's amazing is people assume that a judge is supposed to actually come to conclusions that are based on his wisdom and his years of experience in justice, and the jurisprudence and philosophy of law, and all this stuff they saw on TV that is not real. That's not real. What a judge has to do is rule on what's in front of him. If someone did not give him the evidence he needs for a plaintiff to win the case, the plaintiff just did not provide the evidence, then he can't give it to them, even though it might have been a slam dunk case. And if the defendant did not provide the evidence that would have repelled the claim, and it was a slam dunk defense, the judge can't ask for it. He can't direct anybody. He's not allowed to tell you what to do or what not to do. He's there to just measure what you put in front of him. Right? This is the part that people just have no idea about. The judge is just doing his thing, and he's basically just being a neutral party, observing what's in front of him and coming to a decision based on what people put in the case docket. It's even called a docket, as in what's on the docket. And the idea is that you pull in with your evidence with a ship to the dock, and that's all you got. And the other guy pulls in with his ship to the dock, and that's all he's got. And the judge has to decide between those two things, those two amounts of evidence. And then you get into the case law. So common law courts deal with case law and precedent and all that stuff. So they measure out all what the judge has said before, and then it gets into was it a judge of the same level, or was it a higher judge, such as an appeals court judge that resolved the matter similarly in controversy in the favor of one guy or the other. And people bring in all these cases that are showing that in the similar circumstances, the courts went one way or the other, and it's accepted as that's the way it should go because of precedent. And the thing is that different sides can argue different ways. Even if the precedent went one way or the other, they can say there's exceptions to it, or there's issues going on, or it's different somehow. They're basically working their way to get a win to convince the judge to find in their favor. And what you have to understand is that the judge is supposed to be within the guardrails that I've just described, where he's not allowed to have a personal opinion, a personal point of view. He's supposed to be unbiased. He's supposed to be neutral. He's supposed to be looking out for the integrity of the justice system, not the parties before him. This is where people misunderstand, especially people who are self-represented, or ProSe litigants, as they're called. They get into court and they have this weird idea that the judge is going to help them out somehow. But if the judge helps them out, the case is going to be overturned on appeal because the judge showed obvious bias, which is that then make the system become in disrepute. And they don't allow that. That's why many cases are overturned, because it brings the justice system into disrepute, even though the right thing happened according to morals and societal norms. The thing is when you're in a court case, you're not dealing with morals and societal norms. You're dealing with the judicial system. The judicial system is completely different. It's foreign to morals and common sense and societal norms. It's foreign to all that. It has nothing to do with that stuff. So this is the part that I'm trying to explain here. You're dealing with a completely different system that operates on its own rules. And the judge is supposed to just judge what's in front of him, not anything else. So if you didn't bring it to his attention, he can't observe it and consider it and come into his decision. Now, after all this song and dance goes on and people put all their evidence in to get the facts of the case, put in front of them, and the judge has to, figure out which facts actually matter, because if you put in 20 facts and only 3 are relative to the law that's supposed to decide the case, he has to ignore the 17 other ones. You just wasted all your time. This is where it becomes, once you get more experience, you become more efficient at curating these lawsuits. It's a fascinating thing to be observing, and I've sat through many, many hearings. I've watched this stuff happen. I've been involved in many, many cases myself in multiple levels for multiple different reasons. The point is that this first level of the judicial system is where you get a chance to really argue your case. You get to put everything in that you think could sway the judge's opinion that's relevant to his ability to be swayed by. And this is where most people make mistakes, where they think that if the judge is an honest guy, he'd see what matters here. And the thing is, it doesn't matter whether the judge is honest or dishonest. He is officially sworn to obey the rules of conduct of the judiciary, where it doesn't matter whether he thinks things should go one way or the other. He's supposed to ignore his personal opinions in favor of finding the appropriate judicial outcome. And the thing that is assumed in the judicial system is that every judge is neutral and every judge is impartial. Every judge is doing the best he can in the conditions that they are. And what's amazing is that even if 99 out of 100 judges are completely corrupt, completely politically biased, are complete lunatics, the assumption is the justice is unbiased, impartial, and is doing his due duty as a judge. So people just come crashing into reality when they have this idea of what they think a judge is supposed to be compared to what it actually is in the real world. So anyways, you have this whole song and dance that could go on for weeks. If it's an expedited trial, it's got all these different things. In the meantime, you might ask for an injunction that actually stops or compels someone to do something or stop things. And there's just 101 little things that are steps in between that could happen between the beginning of the trial to the ending of the trial and then afterwards. And if you're representing yourself, you're going to be steamrolled usually, unless you really know what you're doing, which most people don't. And even if you know what you're doing, the judge can just act like a complete lunatic and screw you over, and there's nothing you can do about it. You can try to go and move for an appeal, but even the appeals court, this is where I'll get into the appeal part of it. So you have this first level of court where you get to put everything you want in to try to sway the judge to go on your side. But if 9 out of 10 things you put in there are actually outside of his preview or purview or outside the guardrails of his duty to do things a certain way, he has to ignore it all. So even to any outside observer, say you put the same case in front of 99 people who just looked at the facts, they would decide in your favor, because that's the reasonable thing to do. The judge might decide the other way. Why? Because he's bound by this oath of office and this whole method of operation that has nothing to do with common sense and morals. And this is the point that I'm making. Once you learn what the rules of the court are, and then understand the jurisprudence and understand what the court is bound by, it's in your interest to really hone this thing into what's likely to happen and what they're going to be able to actually consider. Until you know this stuff, you're going to waste a lot of your time. Like 9 out of 10 hours are going to be wasted on writing documents that are irrelevant. They're going to be dismissed even before they're read because they're irrelevant to the matter before the court, the matter in controversy. So anyways, after you've done your best, the other side did their best, the judge retires to his chambers or whatever, says he's going to come to a decision in a couple weeks. He reads everything or not, and then weighs it all out and then comes to a decision. He rules in the favor of one party or the other in some way, and he gives his explanation. Doesn't always have to. Sometimes just have this really brief, like 1 sentence explanation, and it's so vague, you just know that someone won and someone lost. Other times they give their reasoning. Sometimes they'll explain how the decision seems so insane and they'll actually show some mercy by explaining what happened and why he came to the decision he did. All right, so this is level 1 of court. Level 2 of court is if you're appealing that decision. And the thing with appeals is that appeals have to happen quick. You have to file your paperwork usually within 10 days of the original decision coming out, which means that you have to prepare your paperwork in advance before the decision is even rendered to make sure you can actually tailor your appeal to exactly what was said in the decision. So you've got to go through all the usual suspects of what could be the problem, figure out which ones actually are the problem, and then identify how that judge actually ruled incorrectly and why. Now, when you go to appeal, sometimes you're just seeking leave to appeal. So your first round of this appeal process is actually just asking for permission to appeal the decision. You have to show that you have a prima facie case for appeal. Prima facie means it's just on its face, it looks obvious that the appeal should be successful. And then you have to go through your basic reasons of what you're saying, the reasons for the appeal. And then they have to decide real quick whether they're going to give you leave to appeal or not. If they give you leave to appeal, it means that you have the permission to file the actual formal appeal. And then you go through that documents section, and it becomes a pretty big labyrinth. It's got to be very super duper abbreviated, because they deal with high volume stuff and they need to look at the very summation of everything. And if you're not very clear about everything you want and why, you can lose the appeal just by being vague and uncertain about your position because you didn't know how to write it properly. Often they'll just reject your paperwork until you write it correctly. But you have a very limited time window to do this, or they just throw the whole thing out. So anyways, you get this appeal process. Now, once you finally make it to appeal, if you pass all those hurdles and be able to read the rules properly, you're going to this appeal process. And the appeal process is very different than going to court in the normal sense. So level 1, you're actually trying to establish the facts, establish the law that's relevant, establish the issue to be decided by the judge, and then you're trying to sway him to go in your position, whether you're the defendant or you're the plaintiff. Now, on the appeal court side, all of that doesn't matter. All that matters to the appeal court is whether the judge erred, the judge made a mistake somehow, an identifiable mistake in the way he concluded the case. And if he gave no opinion, it's very difficult to find a way that he made the mistake. It's only when he writes a lengthy opinion that you can pick apart the opinion and find errors there. Other times there's other ways, but generally you're trying to find that the judge in the original level 1, made a mistake. And the mistake has to be so big that it'll cause disrepute to the justice system. So it's their team, right? If you can show that the judgment is so egregious, it'll cause the judicial system to be brought into disrepute, right? So they'll lose esteem. Then, oh boy, you got a case there. And if you can actually prove it by providing written arguments in brief and then oral arguments at a hearing, and stick to your guns and be able to convince the 1 or 3 justices that the first judge made a mistake, why it matters to them to correct it, then they might actually rule in your favor. And what they might do, this is where it gets crazy, is they might just order a retrial where you have to do it all again in front of a different judge. Or they might affirm the decision saying they can't find any error in law and the judge's decision was fine, even if there's some little sketchy things going on, right? Other times they'll actually send some specific part of the matter down back to the original judge to redecide it, to basically change his mind on one element. So say there's 10 parts of it, there'll just be one part he's allowed to change his mind on to correct the problem. And this is what'll happen. It goes back to the judge and he gets to do his thing. So this is level 2, which is the appeal process. And if you're not able to win an appeal, you can appeal that appeal. And so this goes to the next level. Depending on your jurisdiction, this would be level 3 of the appeals process. And it either goes to a higher court in the state or province or territory, or it goes right up to the Supreme Court, which is the top court in the land. So what ends up happening is when you go to the next level, so there might be another intermediate level where you have to do it all again and show that the appeals court erred on appeal. So under the usual process of finding that someone made a mistake, you have to point out that the appeals court made a mistake on not finding the mistake of the first judge. So there you go. You got to make the appeals court wrong to be able to go to the next level of appeal or have their appeal reversed and even the lower case reversed going into your favor. So this is where it gets crazy, because you're asking in a court of appeals to appeal the court of appeals lower level group, and these guys are all friends. They all golf together and go to the same parties together. So trying to pull this thing off is not easy. So anyways, you either win on that one or you lose. Then you get to appeal to the highest level. So there either is a 4th level or it stops at the 3rd level. And the top level is usually called the Supreme Court of something or other. And whether it's the federal Supreme Court or the state Supreme Court or whatever, the highest court you get to usually is the federal level, where they only care about if there's a constitutional problem. So in the United States, if you're trying to appeal to the highest level of Court of Appeals, you have to prove that there's a constitutional issue that was violated by the courts in some way. And it gets really convoluted at that point, because you have to actually show that that there's now a constitutional issue at play where your constitutional rights have been violated. And this gets rough. This is where it gets really rough, because you take whatever your original issue was, and then you have to morph it into some sort of constitutional issue, which has to be a violation of the Constitution. This is a whole different game, and you have a very limited time to file your appeal. And you have to be on point or you lose. And what happens, whether it's the Supreme Court of Canada or the Supreme Court of the United States, both of them deal with constitutional issues, and both of them have these gates. What ends up happening is, out of 100 cases, only 3 of 100 will actually be heard by the judge. They're justices of the Supreme Court. So what ends up happening is you might have 100 awesome cases that all qualify on every point, but the judges only accept 3 out of 100. It means 97 out of 100 are rejected just because there's no time to hear them. Then the question becomes, why did they accept the 3 out of 100? And oh boy, that's the golden question. This is where it gets very convoluted, because they start bringing in other rules like, oh, it's a matter of public importance, or a matter of public this and that. It's a pressing political matter. What ends up happening is these cases that get accepted are only accepted because someone powerful wants them to be heard, and they have a reason for it. They're trying to do something. There's a power move going on. This is where they're pushing for some big change to happen. Until you understand this, you might mistakenly believe your matter actually matters. It actually doesn't matter, usually. in the grand scheme of things, because all they care about now is two-spirit LGBTQ plus stuff and climate change. Most of the cases that are going through are dealing with climate change and two-spirit LGBTQ plus plus plus. That's it. There's no time to hear anything else. This is their reasoning. And whether you agree with it or not, this is how they are able to shut out. It's like a filter to filter out what actually matters to people and only allow through the stuff that matters to the powerful. Until you understand, the powerful are using two-spirit LGBTQ plus and climate change as a lever of power. They're able to manipulate things in their favor by looking at everything through the lens of LGBTQ plus or climate change. This is where they're able to bring in carbon taxes, all kinds of insanity that all it does is impoverishes regular people and empowers a different group of people. And it gives more power to the powerful. This is what's so frustrating about it. Carbon taxes do nothing to help regular people. All they do is send big chunks of money to a very small group of people. And that small group of people are the powerful already. It's a tax that just sucks wealth out of the regular economy and hands it over to a group of very powerful billionaires and trillionaires. None of the money that's actually siphoned over for climate change does anything to change the climate. All it does is enrich a few mega corporations who are selling carbon credits and other nonsense. And it's all about control. It's all about stripping you of your ability to do anything so that they become the ones who can tell you what you can and cannot do. They get to be the ones in control. Why? Because of the Rainbow Coalition and climate change. It means you can't have freedom of speech. Why? Because the rights of the Rainbow Coalition and climate change are more important than your right to speak. And unless you're supporting those things, you have no right to speak. This is the convoluted reasoning they're going with to strip you down so you'll have no ability to travel. They'll make traveling in cars illegal. They're going to bring in the CBDCs, which is central bank digital currency. And all of that stuff is going to be tied into climate change and the Rainbow Coalition being protected. Why? Because those are vehicles by which the powerful gain more power. And they're moving towards a one world government. It's going to be a neo-feudal world government where there is no such thing as personal rights. No more such thing as a birthright. That's all old news. And they're going for a different direction, which is a feudal system where they can just snap their fingers and kill you, because that's the power they want. They're done with this other thing that's the transition point. They're moving to this new thing, which is neo-feudalism. So anyway, this is the gatekeepers at the Supreme Court. Very few people ever get their cases heard because they have the gates closed shut real tight, and only the special cases that have special connections get heard to move forward the agenda. Until you see the big picture, it's hard to make heads or tails out of this particular program. So as we're going along here, you got the 3 levels of court. Your first level, which is where the trial is heard, you get to bring in evidence to the judge, and he has the ability to hear different things, consider all kinds of stuff, but he has to stay within the realm of his oath of office and his judicial, basically his job, right? And if you don't like that decision, you can appeal to the Court of Appeals, but they only find either the judge was correct or incorrect in his legal reasoning in such a way that would either bring the judicial system into disrepute or not. And if not, they don't grant the appeal. Simple as that. And then to appeal from that appeal, you have to show that the Court of Appeals erred in such a way that would cause the judicial system to be brought into disrepute. And you bring in why the trial judge originally brought the system into disrepute. And at those levels, they don't care about much of the facts. They don't care much about who did what or when. all they care about is protecting the system so they can maintain the system. And they'll destroy anyone to maintain it. And there's nothing you can do about it because their buddies are the ones who have claimed monopoly on violence through policing, sheriffs, and the military. And as long as we keep putting up with this, it's going to keep going until they switch it to something even worse. So here we go. The laws are put into place by the legislature. The legislature put these laws into place claiming that the Constitution gives them power to do so. What's interesting is no living person has ever signed on to the Constitution. This is a curious thing. How are you bound by a Constitution if you've never signed on as a conscious human to abide by the Constitution? Isn't that curious? They assume you're bound by, but you never signed any documents claiming you would be. Now, there's different levels of the government that used to sign oaths of office that were bound by the Constitution. So it meant that if they did not abide by the guardrails of the Constitution, which limited the power of the government, they could be held liable for that. And it could be a death sentence for them, depending on the severity of the violation. Because they're violating their oath of office. It's actually treason to the people. We the people. Now, because this is becoming more apparent, a little while ago, all these different people stopped signing oaths of office. So right now, it's become crystal clear that the entire appointed bureaucracy of the Biden crime syndicate, no one signed an oath of office. Biden did not. No one below him did. The Department of Homeland Security, Mayorkas did not sign an oath of office. No one who's part of the bureaucracy signed an oath of office. And it's been pointed out to them by multiple people, and they've never made a correction. All they have to do is actually sign the oath of office according to the law, but they refuse to do it. The question is why? The answer, in its most simplest form, is that if they don't sign the oath of office and they do something that's unconstitutional, that could be a death sentence for treason, then if they sign the oath of office, they could face a death penalty. If they don't sign the oath of office, what ends up happening is they're just impersonating an officer, which is just a misdemeanor. No big deal. It's if they even were charged criminally with it, it'd be barely any time at all. Like, no one knows of anyone who's been charged with impersonating an officer like this that I'm aware of. It's a really wild situation. These guys are pretending to be the heads of different offices, and they actually have no legal authority to be that. And the people who know it are trying to scream it from the rooftops, but it's being hidden from the mainstream. People who hear it can't believe it because they think, no, that can't be. Someone would have known something and done something. Yes, they might have. But the thing is, for someone to do something to straighten it out means everyone's got to get straightened out, which means the entire federal government might be revealed to have not signed oaths of office for a long, long time. This could be all the way back to the Civil War. It could be back to the time of the enactment of the Federal Reserve. There's all kinds of different pivot points in the United States history of where things might have went sideways. And then in the Canadian side, the question is, who are they swearing an oath to? And on the Canadian side, anyone from the lowest politician to the local municipality on up, they all sign oaths of office to the Crown. They don't actually sign oaths of office to the Constitution. They're not bound for the people, by the people. There's none of that. If you actually look at the oaths of office, or even the judges all and down, everyone who signs an oath in the thing called Canada, which is not even a country, swear an oath to the Crown. That's who their oath is sworn to, and they swear an oath. You don't get away with not swearing an oath to the Crown in Canada. Why? Because the crown keeps you under their thumb. If you violate that oath, they will destroy you. That could be considered treason in Canada. You ever wonder why some of those politicians come out talking tough, and then a little while later they just get real quiet? This might be the reason. They were brought into the back room with a bunch of men in black and told, listen, if you keep going along like this, we're going to charge you for treason. You're just going to disappear. You're going to be a terrorist. You'll never be seen from again. You're put into a hole and live out the rest of your life in a black hole somewhere. Who knows what's going on? This is conjecture on my part, but I'm saying the evidence is right there. When you look at the oaths of offices for every sheriff, every policeman, every judge, every politician, they all swear an oath to the crown in right of Canada. And what is that? No one's been able to explain it to me yet. I've looked at the British North American Act, and it's vague there. And the thing is, they might have redefined it since, I don't know, 200 years or whatever it is. They can redefine it any day they want and redefine it back the next day to their convenience. This is the problem with having other people have power over you, is they can manipulate you this way, manipulate you that way. It's outrageous. So anyways, those are the three levels, generally. The original trying court, then the appeals court, and then the Supreme Court, which is the appeals from the appeals. Each one is different, and you have to learn the rules of every one if you want to try to be successful. And I know very few people who have succeeded going down this road. And usually when they succeeded, it was a short-term victory that was reversed on appeal later on for some weird technicality that was very difficult to understand. And that was the point. The powerful maintain power. And to go into court is a losing proposition because you're not in control anymore. You're giving control over to people who swear oaths of allegiance to something else. And that something else wants to maintain power. And they don't care who they have to destroy to maintain it. So anyways, that's the summation for the three levels of courts. Now, I'm going to wrap it up there, otherwise I'll keep adding more and more info, but that gives you the general idea. The one thing I want to, there's two more terms I want to throw in there before, in the end, I guess, of this section is, there's a matter called res judicata. Res judicata means the matter is settled. It can never be reopened again. And res judicata means that if you filed a lawsuit and you won or lost, and the time for appeals has passed, as in the 10-day window passed, no one filed an appeal, it means the matter is res judicata. It means you cannot do anything about that again. It cannot be reopened. It's over. Now, the whole point of, the whole point of res judicata was so that people didn't continue fighting forever in court, because then it would just, whoever had more money would win by way of attrition. Now, the problem is, this sounds like a lovely idea, right? You get to have your day in court, you get to deal with appeals once, and deal with appeals secondly, the matter's over. But, this is an interesting concept, and they're able to actually fudge this many ways. The whole point is that it sounds lovely on concept, but in reality, you could have a court matter go on for 10, 15 years without ever even hitting appeals yet. There's no time limit to court procedures. And it used to be that in criminal matters, at least the matter had to be quick because your life was in jeopardy. And then since COVID, they did away with that. They said, we're not going to bother with the speedy trial thing because it's more important that judges not die of COVID and they just stay home and do Zoom calls or whatever than it was to actually have speedy trials. So since COVID, they actually changed the rules of court, and you're no longer guaranteed a speedy trial, even in criminal matters, because they, with a stroke of the pen, they changed the rules. Now you can rot in jail for years waiting for your trial that may never come. As an example, if you look at the J6 defendants, those poor guys have been sitting in jail for 2-3 years, some of them 3.5 years, and they have not had their trial yet. The prosecutors have not had to show evidence. The charges against them have been shifting repeatedly, so they're not even sure what they're being charged with. And until you understand, the District of Columbia is something else. The District of Columbia is not part of the United States of America. The District of Columbia is a completely different entity. It's part of the 3 cities organization. One is the District of Columbia, the other one is the Vatican, and the third one is the City of London. These 3 were 3 centers of power not long ago, and they still are. It's a completely different jurisdiction in the District of Columbia. They claim to be operating on their own territory that's outside of the Constitution, and everything they do there, it cannot be unconstitutional since they're not subject to the Constitution. It's actually its own little city-state, and when you start realizing that, it'll start making more sense. But this is the problem with people not knowing that they've been lied to their entire lives by the apparent government, who is basically trying to maintain power for the powerful. And it gets very convoluted and confusing, and there's many different theories of what happened there. I'm not going to get into that today, but the whole point of the judicial system is that you never know what jurisdiction you're in. And there's one other thought. There's a thing called res decisis, or stare decisis, sorry. Stare decisis basically means this matter has a precedent. It's been dealt with by precedent. And precedent means that similar parties in similar circumstances have had a decision outcome in a particular way. And the judge hearing the matter today should rule in that particular persuasion. And it becomes an interesting thing because with stare decisis, even though the judges in common law courts are supposed to give deference to these court cases that came before them, they can just decide to ignore it because they have this thing called judicial discretion. And judicial discretion is the holdout, like I told you, from back in the day when the king could just do whatever he wanted. And what ends up happening is they can just rule however they want. They can ignore all the precedent and just do their own thing. And there used to be a court for this called the what was the name of that court? The Court of Chancery was one court that did it, but it's basically the ability, courts of equity. This is where they can claim equity jurisdiction to basically do whatever they want to find justice between the parties, however the judge sees fit. This is where it gets into dangerous because with when you get into court of equity, as in they decide they're going to provide an equitable outcome, there's no rules that can be relied on at all for anything. And it becomes pretty ridiculous because they don't have to actually explain themselves. They can just rule however they want and it's over at that point. They don't have to actually rely on any rules this way or that. They don't have to explain themselves. It's just whatever they want to do, they do, and good luck trying to reverse that later on. So yeah, I'm going to wrap it up there. So on this judicial system part, this segment, I'm going down a steep hill and I don't want to slip. We will close with a prayer. God, please move the hearts of the listeners. Move them in the spirit as only you can, to be better, choose more, and be examples of what you intend your children to be. Remind us in ways that only you can, that we are the children of God. We have free will. We are co-creators of this beautiful world that you gifted to us, and we will have abundance if we but choose to, and act to manifest it. God, give them a vision of how they can fulfill their destiny as individuals here and now. We ask that you inspire us to be fearless warriors in spirit and the sword, to be shining examples of what we can do with our divine potential. Fear not, fear not, fear not. We ask that we manifest unwavering courage, the conviction and the heart to live a life worth living, and to do our part to manifest a godly realm, full of peace and love and abundance, here and now. We claim our space as holy. In the name of Jesus Christ, we put on the armor of God and we pick up the sword of the Spirit. We will act to expand the kingdom. We will manifest goodness in this world. We say these things in Jesus' name. Amen. All right, so that's my podcast. My first podcast, kind of giving a broad overview of the courts and the court system, how it works, some of the language, some of the explainer of how we got here, some historical context, and some kind of modern stuff. I decided to not add a bunch of cases that are ongoing because it just gets convoluted. People have a hard time following what's going on in like live courts because everything is so convoluted and ridiculous. And there's even reporters who don't really understand how the court system is working. So they go into these courtroom hearings and they report on what they're seeing, and they're misunderstanding the verbiage, the language, the context. They're misunderstanding everything and then reporting their own perspective about what's going on, which misleads people. So I'm going to avoid that unless I'm actually in the court and I can hear with my own ears or listen to a audio recording in the court. I'm not going to make judgment of what's going on or give, commentary because I think it would be not useful. But this podcast on the general history of courts, how we got here, and how it generally works, so it'll demystify it for people. I think that's going to be a valuable contribution so that people can wake up to the system that's all around you. What's amazing is I ask you, did you sign a contract whereby you would abide by the court's rulings? The answer is no. You don't have to think too hard about it. I know you didn't. No one did. And I have to ask you, did you sign a contract whereby you agreed to abide by the executive system? The answer is no. And I'll ask you, did you sign a contract regarding the Congress or the guys who are making the laws? And the answer is no. What's amazing is we've never actually agreed to any of this stuff. Yet they make assumptions that we did. They're assuming we agreed to it, and that's how they gain their power, even though it's false, it's a fraud. They assume that we granted them the authority to do what they're doing. But we didn't. And the thing is that you didn't, and I didn't, sign on to the Constitution of the United States or Canada or England or any other country. They never asked us to sign on, because if they asked us to sign on, we'd think, wait a second, I don't have to sign? I have the option to not sign? And that's why they won't give you the option to not sign on to a constitution. They've got to pretend that they have legal power over you when they don't. They don't actually have any lawful power over you. This whole system is run by way of fraud, misrepresentation, and force. They claim monopoly on force. They claim that they have the lawful authority to be able to enact a police force who do the bidding of the mayor or whoever's in power in that area, which they don't have the authority to do so. They don't have the authority to actually enact an army and force you to go fight in the army for their interests. They don't have this authority, but yet they pretend that they do. On top of that, they claim they have the authority to appoint sheriffs who have the use of force authority to arrest you and drag you from prison cell to prison cell, but they don't. And this is the part that they don't want you to know. Because unless you actually signed on a contract for performance, you don't have actually any obligation to perform. And usually when you sign on a contract for performance, in the contract it'll say what you're supposed to do, and then in the contract it'll say what you're going to receive in compensation. That's considered valuable consideration. It's what's the value being considered by both parties to the contract, and what are you getting in exchange for what you're giving. That's how the rule of contract works in the legal and lawful side of things. These guys are operating completely outside that. They're pretending that a document enacted a couple hundred years ago by people who have no relation to you somehow bound you to that document. And it bound you to their power because they're operating under the apparent authority of that document. This is what's fascinating. This is the thing that they don't want people to know. They don't want people thinking like this because it'll upset the population. It might get the population thinking, wait a second, what's going on here? And there's a basic maxim, a legal maxim, M-A-X-I-M. Legal maxims are these principles that are considered so obvious that they become law over time, and they basically govern the courts. The courts have to follow these maxims because the legal maxims are basically things that are so self-evident that it shouldn't need to be said, but they say it so that people can't escape it. And one of the legal maxims that's so important is called the fraud vitiates all contracts, which means it abolishes all contracts. If there's any fraud that's used to induce someone to sign the contract, then the contract is destroyed ab initio, which means at the beginning, from the beginning. There's no point in time that contract had any validity. And what this means is that if you're fraudulently induced to sign a contract for performance, then you actually have no duty, legally, lawfully, or otherwise, to perform according to that contract that you were tricked into signing. What's amazing is these guys are tricking you into performing for a contract that, number one, does not exist, and number two, you never signed. So it's even beyond that, and that's how they've gotten away with this scam for so long, is it's such a big lie. It's so gargantuan, and it's so pervasive in your entire life, in all the lives of everyone you know, that people just can't believe it's true. Because it's just so big. It can't be true. It's just too big. The consequences are too serious. And this is how they keep getting away with it. And as we go forward in time, and there's a certain part of the population who are realizing this and becoming more and more and more aware of it, the powerful are working harder and harder to bring in censorship. And they want to bring in prison time for anyone talking about this stuff because it makes them uncomfortable. It's speech they hate, which they will call hate speech. And they will imprison their political enemies to make sure the power structure stays in the hands of the proper powerful people. This is what's going on. And when people start thinking this way, they start realizing, wait a second, there's like scams within scams. And then you realize that, wait a second, it's not only the federal government that's a fraud, because you've never signed on a contract to actually perform, and then you don't even know what you're getting back. But then there's the state or province side, where have you signed a contract with them? No. And then there's the city side. Have you signed a contract with your local municipality? No. See, all of them use the same trick to gain power over you. It's the assumption that you're obliged to follow them because of some vague idea that they're the government and they're bona fide and they're legitimate. Why? Because people have thought they were legitimate for a long time. And that's the general consensus being created by the media, by the politicians, by the courts, and all that stuff. It all works together to make the air of legitimacy when they're really not. This is the trick. It's just a huge theater, and they're playing their parts. They're pretending to be courts. They're pretending to be politicians. They're pretending to be the legislature. They're pretending to be the judiciary. They're pretending to be the executive, when really they're not. It's just a giant theater, and they have no actual power over you. When you actually get back to the laws of nature and the laws of God, that's where you realize these guys actually have no power over you. And they are deathly afraid of you realizing that, because you'll stop acting as if they do have power over you. So there's been many different groups over the years who have tried to push back and demand the contract and demand this and that, and they never succeed in court in any meaningful way. They will win court cases here and there in some minor way, and then it'll be overturned on appeal, and all kinds of crazy things happen that are just outrageous. But there's no one around who claims to be in power who will do anything to change the system, because them being in power, which is fake, is dependent on them pretending the system is legitimate. That's why things don't change. That's why we have to change ourselves first and change how we see the system and how our friends see the system. This is knowledge will set us free to a certain point, but then we have to actually act to become free. And peaceful non-compliance is the way to start. And we just have to stop pretending that they have authority over us, and their authority evaporates. It's as simple as that. Peaceful non-compliance with full knowledge that they have no authority and they have no power. Their power evaporates, and the more of us that wake up to this, the less power they have. They don't have enough guys to physically beat us all up. Only when we're very few do they have enough guys to beat us up. These are called the police and the sheriffs and the military. Those guys are paid to beat us up, and they don't realize we're fighting for them too. We're fighting for them to be free, and they have no idea, or they're too corrupt to care. So this is the amazing thing about the judicial system. It's a giant fraud. It's a theater. People pretending to have roles, and they have all these psychological operations going on. When you go to the courthouse, it's never a low-lying courthouse. It's always this grand structure. You walk in with these like high ceilings, and everything is very grand and big and antiquated, as in it's antique, and seems like it's been there forever. And you're just the latest guy, a come-along guy, and you're supposed to have respect for the system. What they don't seem to, and this is all about making you feel small. The judge always sits on a higher platform than you to make you seem small, to make you look up to him. These are psychological tricks that are all along in a spell operation to put you in a trance whereby you think you need to take on the role of the person who has no power, and you're asking them to do this and that for you because you have no power on your own. That is not the truth, but it's part of the magic spell to disempower you. Until you realize this, it's hard to see what's really going on. That's why podcasts like this are so important. There's another guy that I really listen to a lot called Legal Man. He has a podcast called The Quash, Quash, The Quash. And if you ever want to listen to him, he's an American retired lawyer, and he tells it how it is. He's pretty funny. He's a bit vulgar, so I don't recommend it if you're sensitive to language. He drops F-bombs and more. But his perspective on legal matters is very profound. I listen to him all the time to gain insights, and he does a lot of readings of Spooner and other really great writers from back in the day, and his perspective is spot on in many ways. He deals with just the surface level things. I deal with more historical, kind of deeper context, but I'd recommend check out The Quash. It's a free podcast you can download here and there, and fun stuff if you're actually interested in this kind of thing. The problem is when you start actually trying to engage the system, this is a beast system, and you will get bit. And there's guys who encourage people to become ProSe litigants and to pursue their matters. And there's guys who offer courses on how to fill out paperwork and things like that. If you want to go down that road, you can. I just have not seen anyone actually be successful at it. See, what's amazing is, and there's guys that I have respect for that actually have been recommending this and going down the road. And most of them that recommend this have never actually won a court case. They might have 4 or 5 going right now because they thought, hey, I might as well file these, but they've never won yet. And then there's guys who are lawyers who are creating these courses. There's a guy named Graves. He's a retired lawyer that helps other people file lawsuits. He has this whole course. You can pay like a few $100s, and you go through this course. It gives you step-by-step what to do, how to file the paperwork, what language to use, and basically holds your hand the way through. And you can start fighting your own fights in court. The thing is that there's no guaranteed win in anything. And what's amazing is when I'm listening to these guys who are, newly minted pro se lawyers, they don't really understand a lot of the background to the system. They understand the surface level, what's written on the paper. And this is the part that's kind of infuriating, is that what's written on the paper is not what happens in court. Even though the rules of court are all there, this is the guidelines by which you're supposed to do this and that, file motions and argue this and that. It tells you what to do generally for paperwork in the rules of court. But that's not actually the rules that are being operated by the powerful. And that's why I'm giving you the historical context whereby we're dealing with the shadow people who are actually in control of everything. And in front of them, you've got Team Evil. And Team Evil wears many hats. And they pretend to be politicians, they pretend to be judges, they pretend to be lawyers. But they're actually just maintaining the system for the powerful. This is why guys who don't know any better will go into court and try to win stuff, and they'll spend years, and even though they're not paying for a lawyer themselves, they'll spend years working on a case, and they'll have a slam dunk case, and then at the very end they'll lose, and they just can't understand why, but then they'll appeal it, and they'll lose the appeal, and they can't understand why. They'll appeal that, and they'll keep appealing, and they'll keep spending until eventually there's going to be a judgment that's going to be against them, which they'll have to pay $100,000, $200,000 in lawyer's fees to the other guy who they should have won. As in, the guy filing the case should have won for every legal reasoning that's out there. They just, on all points, it's a slam dunk case, but yet they lost. And then they were unable to overturn it on appeal. And what's amazing is that these guys will still end up with a judgment against them that they have to pay the lawyers who defended the dud case that should have lost, and they have to pay the lawyers' fees of $200,000. And if they don't pay within a certain period of time, if there's any house in their property, if they have a car, anything that's registered in their name will be seized by the courts to pay the debt to those lawyers. And this is the sucker punch they don't see coming. This is where you have to get into legal trusts and get everything you own. If you're part of a legal case, get everything you own on paper out of your name and into a trust. Because if everything breaks loose and you lose this thing big time, at least they're not going to be able to seize your house and your car and everything registered. At least it'll be out of your hands. Anyways, I'm going to wrap it up there because I can just keep talking about this stuff. Thanks for listening. I appreciate your time listening to this podcast. I do appreciate all the listeners and the comments coming and the emails coming in. I thank you for your attention and your time. And I'll keep trying to make these podcasts as long as people are interested, and being shadow banned everywhere. So please try to like, subscribe, share it with your network wherever you can to try to grow the group. The more the merrier. The more people that know this stuff, the less likely they're going to succeed at their evil agenda. So thanks for listening. That's all for now. God bless.